Actus non facit reum, nisi mens sit rea. An act does not make a person guilty unless the mind is also guilty. But what exactly does a guilty mind look like? That is what this lesson is all about. Mens rea is the mental element of a crime. It sits at the heart of every serious offense, and it comes in several forms, each demanding a different degree of fault. We have 5 key concepts to work through: intention, recklessness, negligence, transferred malice, and the coincidence rule. Intention is the highest and most blameworthy form of mens rea. We divide it into 2 types. Direct intention is straightforward. D acts with the purpose or aim of bringing about a particular result. If I shoot someone wanting them to die, I directly intend their death. Oblique intention is harder. This arises where death or serious harm is not D's purpose, but it is a virtually certain consequence of their actions, and D appreciates that. The leading case is R. v. Woolen, 1998, where the House of Lords held that a jury may, not must, find intention where the result was a virtual certainty, and the defendant foresaw it as such. This gives the jury a moral escape valve. They can withhold a finding of intention even where the test is technically met, if it would be unjust to label D an intentional killer. The word may is crucial. It preserves jury discretion. Recklessness sits below intention on the fault ladder. A reckless defendant foresees the risk that their conduct might cause a prohibited result, but proceeds regardless, without justification. The critical word is subjective. It is about what this defendant actually foresaw, not what a reasonable person would have foreseen. This was settled in RVG 2003, where the House of Lords overruled the earlier case of RV Caldwell, 1982. Caldwell had controversially introduced an objective test, meaning D could be reckless even if they never thought about the risk at all. The House of Lords in RVG, involving 2 young boys who started a fire, held that convicting someone who genuinely did not foresee a risk was unjust and contrary to principle. So today, criminal recklessness in England and Wales is always subjective. D must have consciously recognized the risk and unreasonably taken it. Negligence in criminal law means D's conduct falls below the standard of the reasonable person. Unlike recklessness, it is entirely objective. We ask what D should have foreseen, not what they actually foresaw. Negligence as a standalone mens rea is rare in criminal law. It is more at home in tort. However, it features prominently in gross negligence manslaughter, where D owes a duty of care, breaches it so badly that it goes beyond mere civil negligence, and that breach causes death. The leading case is R. v. Adomarco, 1994, where an anesthetist failed to notice a disconnected breathing tube. The jury found his negligence so serious that it justified a criminal conviction. The gross threshold is what separates criminal liability from civil liability in this context. Transferred malice is a doctrine that prevents D from escaping liability simply because their mens rea was directed at one person, but the actus reus fell on another. The classic case is R. v. Latimer, 1886, where D swung a belt at one man. It glanced off and struck a bystander. D's malicious intent towards the first man transferred to the bystander, satisfying the mens rea for the offense against her. The rule works when the offense committed is of the same type as the offense intended. So if I intend to kill Ali and accidentally kill B, I am liable for B's murder. But if I intend criminal damage and accidentally injure someone, the malice does not transfer across offense types, confirmed in R. v. Pemberton, 1874. Here is your check for understanding question. Dan throws a punch at Ali but misses and hits B, breaking her nose. Dan had no intention to harm B. Is his mens rea satisfied for battery against B? Option A, no. Dan never intended to harm B. Option B, yes. Intention transfers from Ali to B under the transferred malice doctrine. Option C, yes, but only if recklessness suffices for battery. Option D, no. The coincidence rule is not met. The answer is B. Under the transferred Malice doctrine established in Latimer, Dan's intention to batter Ali transfers directly to B. Because the offense is the same type, battery in both cases, the transfer works perfectly, and Dan's mens rea is satisfied. Mens rea is not one thing, it is a spectrum. At the top sits intention, both direct and oblique. Below that, subjective recklessness. Negligence plays a limited but important role, and the doctrines of transferred malice and coincidence ensure that D cannot escape liability through technicalities of timing or targeting. Your modules, mapped to your uni. Explainer videos for every topic. A tutor that knows your course. Essay writer for your essays and graded. Case briefs, flashcards, annotations. Try it free for 7 days. Link in the description.